next, I guess.
Okay, we are live.
Morning, this is Senate Judiciary. It is Tuesday, February 28th, the last day of February. And I'm remote here in Bennington due to COVID, and hopefully we'll be in Montpelier next week, or tomorrow, as I seem to be getting better. Eric is going to walk us through draft 5.1 of S4 and see if we have a number of changes, and I believe they're highlighted. So Eric, if you want to take over.
Will do. Thank you, Senator Sears. I'm just trying to join the meeting right now. I had a funny response, but I seem to
Join now. You're co-host now.
Thanks, Senator. Thanks. Thank you. All right, Senator Sears, I'm just pulling up the most recent version. As you mentioned, it's version 5.1. So I'll be able to share that with the committee in a moment. I think does everybody have that on the screen okay now?
Yep.
All right. So yes, if you, Eric Fitzpatrick with the Office of Legislative Counsel is here to talk with the committee about the most recent version of the Judiciary Committee Strike All Amendment to S4, Act relating to reducing crimes of violence associated with juveniles and dangerous weapons. There are a relatively few number of changes between this version and the previous versions, and those changes are highlighted. So we can take a look at those to start, and then circle back if anybody wants to talk about any other non-highlighted issues. So the first one you see is on page 3. This has to do with the Big 12 again, and perhaps soon to be a different number. You see right now the version that the committee is looking at increased the Big 12 offenses by several. And this particular addition has to do with one proposed offense to add to the Big 12. Remember, that's the offenses that have to start in the criminal division when a youth is charged with the offense, as opposed to starting in the family division. That's what Big 12 refers to. So I think everyone had agreed on the non-highlighted language. This is page 3, lines 3 to 5. And this is adding the offense of violating a condition of release imposed by the criminal division. Remember, the idea there was to try and have all the proceedings against a given youth be in one court. The problem had been that if someone had been either transferred up to the criminal division because they were part of the Big 12, or because one of the offenses was filed there originally on account of being part of the Big 12, the proceeding against the person would be in the criminal division. But if they violated the conditions of release that were imposed on them in their criminal proceeding, a violation of conditions of release charge is a misdemeanor, not on the Big 12, so that would be in the family division. So here you'd have the same case, essentially, involving the same person. You'd have part of it in the criminal division, part of it in the family division. The idea was to find a way to resolve that problem. So the proposed way to do it is add it's what you see in lines 3 to 5 to start with. Okay, it's a violation of conditions of release for one of these offenses, which means it's already in the criminal division. Well, then you keep that violation proceeding in the family in the criminal division also. So the proposed clarifications are lines 5 to 6. First of all, so it's not only for this will not only be for a Big 12 or Big 18 or whatever it ends up being case that started in the criminal division. This would also be the case for, you see lines 5 and 6, for any other offense that was transferred from the family division pursuant to this section, because you may recall that even if you're not part of this Big 12, Big 18, whatever it is, there's a way in which for a certain other felony charges, other offenses, the state's attorney can make a motion to have a case transferred from the family division to the criminal division, even if it's not one of the Big 12. And the idea was, well, if that were the case, if that's how it gets to the criminal division, it should still be the same process. It should still be the same, that the violations of condition of release should stay with the offense. They should be in the same court rather split up into different courts. So that's what lines 5 and 6 covers. However, this was something that was also brought up at the last hearing. There was also the possibility that if it's in the criminal division, it could get transferred down to the family division as a youthful offender proceeding. So that's what lines 7 to 9 cover. Say, okay, well, if it's in the criminal division for one of these offenses that got transferred up, or because if it's one of these big 12 offenses, yes, generally speaking, violations of condition of release, they get filed here in the criminal division too, except or unless, as line 7 says. But if the case goes down to the family division for youthful offender treatment, that won't be the case, because think about it, that would create the same problem, because if the case goes back to the family division, you don't want the violations of conditions of release charge being filed in the criminal division at that time, because then you'd still have them in 2 different places. So that's why it says unless. If it goes back to the family division for youthful offender, well, in that case, the violations of conditions of release is not going to be a big 12 offense, so they would both be together in the family division rather than the criminal. Long explanation, I know. Probably hard to keep track of a little bit, but hopefully that kind of gives you a sense, and that the purpose of it all is to keep the underlying offense and the violations of conditions of release for that offense in the same court, whether it's in the criminal court or the family court. Does that make sense? That's all right, so let's see what the next change is to the previous draft. This has to do, this again, the ping pong issue. We've been talking about that. That's the effect of the way the current law is structured, that if in order to get to, unless a case is direct filed as a youthful offender proceeding in the family division, unless that's the case, in order to become a youthful offender case, the case has to go, excuse me just a second. The case has to go from the family division to the criminal division and then back down to the family division for youthful offenders. So everyone agrees that that's inefficient, not the way that these proceedings should unfold. So the partial way to address that was agreed upon, that you see at least the first few lines of subdivision 3, is that it allows the parties to stipulate to convert a juvenile proceeding to a youthful offender proceeding. So rather than having to go up to the criminal court and go back down to the family court, instead the parties can agree, hey, this case is really better suited for a youthful offender type of case. And I think you've heard some testimony that will, while not resolving all of these situations, will at least resolve a good number of them, because many times the prosecution and defense can see that a particular case is better off being handled as a youthful offender proceeding. So this allows for that, provides that if the parties do agree to convert the proceeding to youthful offender, then the court can go immediately to a YO, youthful offender hearing, rather than having to go up to the criminal division, go back down. So immediately to a YO hearing. So it's, in other words, you're just staying right there in the family division, staying right there in the same court, just converting it to a different type of hearing. And it allows, you may remember DCF testified about this last time, that they generally do a youthful offender consideration report in youthful offender proceedings to provide the court with guidance about whether or not this is an appropriate YO case. And in order to make sure that that report still gets done for YO cases that are converted the way that we just described, that's what that last sentence says, lines 15 through 17. It says the court shall request that the department complete this YO consideration report before accepting the case for YO treatment in the subdivision. So the court will still get the report from DCF about whether youthful offender treatment is appropriate in the case. So that's the idea behind that one. So we move on, check out the next change, or the next highlighted version, I should say, because I think this next one isn't actually a change. Remember, this is highlighted. Oh, sorry.
Sorry, Eric.
Yes.
Before we go on section, or we're getting into section 6 now.
Right.
Okay. So something was brought to my attention by the Defender General's office, and it involves, I believe it involves section 6 and, oh, one second. It involves section 5 and section 4, actually.
Okay.
And one of the concerns is that in chapter 2, section 40 of the Vermont Constitution, it states that a person accused of a felony, an element of which involves an act of violence against another person, may be held without bail. And the concern is that in subsection D of section 4, for example, it states conduct constituting the offense of defacing a firearm serial number shall be considered a violent act for the purposes of determining whether a person is eligible for bail. So does it have to reflect the language, or rather, should it reflect the language that's in the Constitution is my first question. Then there's also the question of whether this can be considered a violent act under that chapter, or under this section in chapter 2, if that makes sense.
Yeah, the latter question, I think the answer is yes, the legislature can do that.
Okay.
And there's number of other statutes on the books in which the legislature has already done, that this isn't being done for the first time.
Okay.
So, and the language now tracks, I think 7559A, the bail statute. So I'll look into that first part of your question, but I think, remember, this language isn't saying that a particular offense bail is required, or that bail cannot be imposed, I should say. It's only, if we look at that statute, which I think I passed out to the committee earlier. Yeah, here we go, 7553. So this provides that a person charged with an offense that is a felony. This tracks the constitutional language that I think you were just reading the center sheet. Person charged with an offense that is a felony, an element of which involves an act of violence, may be held without bail when, so these other criteria have to be found by the court, when the evidence of guilt is great, and the court finds, based upon clear and convincing evidence, that the person's release poses a substantial threat of physical violence in person, no condition or combination of conditions of release will reasonably prevent physical violence. So the court still has to make all those findings. This saying that an offense shall be considered a violent act only satisfies the very first element of criteria that the court is going to have to look at, which is that the offense involves an offense an element of which involves an act of violence. So it satisfies that. It doesn't relieve the court of the responsibility of having to make a bail determination based on whether or not there's clear and convincing evidence that the person's release poses a threat of violence to any person, and that no condition or combination of conditions will prevent the person from appearing. So I'll look at how that statutory language dovetails with the constitutional provision that you just mentioned.
Yeah, I just want to make sure that I'll just leave it there.
Right.
You do your thing.
Yeah.
Thank you.
Yeah. So then that does bring us to section 6, and this is the sort of unresolved question that the committee had been talking about, which is, do you want the prohibition piece, which is defining who it is can possess a firearm and who cannot legally. So it's basically creating or adding a couple of prohibited person categories to the existing statute that prohibits people who are convicted of certain offenses or are subject to certain proceedings from possessing a firearm. And you see the committee had still been talking about subdivision 3, which is whether a person subject to an order against stalking, and this is a civil order against stalking, should be permitted to possess firearms. So again, remember the distinction that the committee talked about between a relief from abuse order and RFA, which would apply when the stalking order is issued against a family member or a household member. If that's the case, then the conduct of stalking has to be subject to a relief from abuse order, not a stalking order. So an order against stalking that's issued civilly is only going to involve people who aren't either family members or household members. So that's the difference. And the question is, as a policy question for you all, whether you want the firearms prohibitor to apply to that group too. So we percolate on that for a moment, and then move on, just so we've covered all the, I almost think that right. So then another question in the grant program, the community violence prevention program, on page 13, you see line 17. This had to do with these are the organizations that can apply for the grants. And the thought had been whether or not it should be limited to a nonprofit organization. Municipality, I think everyone agreed, municipalities can apply, should be organizations or nonprofit organizations. I think that's where the discussion led last time. Again, another policy decision for the committee.
Yeah, I think one of my questions, not that I'm necessarily opposed to it, but why are we making the delineation between nonprofit or for-profit organizations? I'm just curious about that, if there's any thoughts on it. I don't know where it originated from, but.
I think it was Senator Sears' idea, but I certainly, support trying to keep, I think how I want to word this, but really trying to keep this kind of like community development work in the hands of communities and nonprofits rather than for-profit.
I was the one who suggested nonprofit. And my concern is some of the profit-making organizations are, not only statewide, but nationwide, who might come in, and we get these requests frequently. And I think keeping it to nonprofits at least limits it to some extent. My hope is that that at least Commissioner of Health will use, that are basically are community-based organizations. Maybe that's a better term. A municipality or community-based organization may submit an application. This is really what I'm looking at.
I think
Could your Justice Center, for example, put in a grant?
But they would be a nonprofit, yeah.
Right.
Housing trust, nonprofit,
Right.
like.
Yeah, there's also $1 million businesses that are nonprofits, like Blue Cross Blue Shield, for example. I mean, the first thing I'm thinking of is, the several mom and pop shops in a downtown district coming together to try to put something together for this grant. They are for profit, but maybe community organizations, I think, could be helpful, and that could make it more local instead of worrying. Because if it's focused on community organizations, you won't have to worry as much about large out-of-state corporations trying to get involved in this.
Yeah, I just probably, yeah.
Is there a legal definition of community organization?
I don't.
Whereas there is a legal definition of non-profits. I don't know, as a general rule, like community development and community health and safety, I like to keep that out of the hands of people who are going to profit from that.
Yeah.
So my question, Eric, on this one, so the way this is written, is this strictly for municipalities or nonprofit organizations in the state of Vermont, or can nonprofit organizations from outside the state of Vermont apply for this? I think that would defeat our.
Right. Yeah, you might want to add Vermont, just to be clear on that. I think probably the Vermont, I think the intent certainly is to cover Vermont communities. So just to be clear, so there's no ambiguity, it's a good idea.
I think that helps.
Would we be allowed to prohibit out-of-state organizations from applying?
Yeah, I believe so. I don't think that would be a constitutional issue, just for not a fundamental right. You have a rational reason to distinguish between, you're trying to improve safety in your own state communities, so only state entities or state organizations might.
Eric, would putting in Vermont, so one of the things that I found sort of during my research on this bill was that the US Department of Justice has some really great programs on exiting youth out of gangs and supporting youth in that way. if we add Vermont, would it prevent a municipality or nonprofit from working with the Department of Justice in a program like that?
I don't think it would prevent them working with them.
But it would prevent the Department of Justice from
Being the
getting that money.
applicant.
Oh, from being the applicant, but they
Right.
could still, if the applicant could still use that money to contract with the
I think so.
DOJ.
Right.
Well, and I suppose you have to then say that a municipality could work with a for-profit, right?
Mhm.
I thought she was mentioning the Department of Justice.
No, yeah, but I'm just saying, if we're talking about this language covering the applicant, it wouldn't necessarily prevent a for-profit company from being involved in the application of the grant.
From being contracted in like the DOJ.
Right.
Yeah.
Yeah, so I think, yeah, right, I think that'd be a policy decision for you as to whether, maybe you want that, maybe you wouldn't.
I don't have as much concern about a municipality or nonprofit contract. I mean, as much as I don't want, for-profit companies profiting on community violence, I feel like in the world that we're in, sometimes that is the only avenue. So I don't feel like I have as much concern with allowing a nonprofit or municipality to get the required services from potentially a for-profit organization. But I have more concern with a for-profit organization being the one that holds the money and gets to make the choices, if that makes any sense.
I think it makes a lot of sense. I'm comfortable with the way it's written because I know the Appropriations Committee will go over it and this section, so.
Senator Sears, do we want to add Vermont to sort of clarify?
I think so, yeah. I
Okay.
think that would probably be helpful. It wouldn't prevent a Vermont municipality from contracting with another organization as part of the grant.
Yeah, I think that's right, Senator Sears. Right, as long
Like,
as-
you know,
as long as
I'm
the
thinking that,
municipality-
and I'm not suggesting the International Chiefs of Police Association, but I know Bennington contracted with the International Chiefs of Police organization early on in their effort to deal with some of the issues within their police department. And so as long as it wouldn't prevent them from entering into agreements as part of their grant with other organizations.
So at a Vermont municipality or.
Yeah, I mean, those are the people who would get the money. What they do with it would be up to the Commissioner of Health.
And I think that might be the last change.
Yep.
Right, so I think the only.
Well, you forgot to mention you took out Section 8.
Oh, right, sorry, thank you. Yes, that's no longer in this draft, the under 21 possession of assault weapons section. So I think the last piece, one of the last pieces anyway, is the stalking order piece.
Where's that here?
So that is on page 10.
It's a civil order, right?
Yes.
I guess my question on that, Eric, would be, it's civil order, it's based upon granting this, is it based upon the preponderance of an evidence or clear and convincing when they grant these orders civilly?
Generally, preponderance is the standard in civil matters, and I think that's the case with respect to stalking orders, but I can just check that. for you.
I wonder if there's anybody in the audience who would like to speak. I won't be able to see you, so I'm going to ask the vice chair to if there's anybody who would like to discuss this issue specifically. Jared?
Senator
So
Bowles?
there's-
Yeah, I mean, I certainly have brought up some of my concerns and I don't know what the right way is to narrow it, because I certainly hear, that we don't want to capture sort of petty neighbor to neighbor conflicts. And I think incredibly dangerous stalking happens even outside of households and family members, whether that is someone who is infatuated with someone who doesn't share those feelings, whether that is someone in public office, whether that is, I think there's a lot of instances in which actually incredibly dangerous stalking happens that wouldn't be captured under the relief from abuse order. And I hear that this particular definition may be overly broad. I don't really know what the answer is, but that's my non-answer to the question.
I saw Jared's hand up, but is there anybody else? No. Jared, did you want to speak on that stalking?
I'm sorry, no, Senator, my apologies. I was had a slight comment, a very small comment about another section.
Okay.
You have the Defender General's office wanted to chime in. Senator Sears?
Okay. Yeah, go right ahead.
Thank you, Rebecca Turner, for the record from Defender General. Certainly Senator Biofsky's concern about the broad reading of stalking legally, it absolutely is. And I've testified already on the Second Amendment problems that the other subsection, certainly this subsection has the same concerns with the Second Amendment. In terms of challenging what is falling under the meaning of stalking, we have challenged under First Amendment grounds and other contexts. So there are separate concerns in terms of the broadness and whether there's notice issues as well. So I think the addition of this is an absolute broadening of the effect, which is who are you now prohibiting absolutely from possessing firearms? Now you're capturing an even greater activity whenever you have and use these broad and vaguely defined terms that just hands over a wide amount of discretion to the prosecutors and all of the attendant issues. In the First Amendment context, it's the chill. In the Second Amendment context, it's the possession of a fundamental right to bear arms. Because what does it mean, right? And what gets you subject to falling within this final order of stalking?
If I could ask, so we're saying it's the subject of a final order, but doesn't that put the power in the hands of the judge?
To make the ruling of as to whether the conduct falls into it, the question is whether or not the conduct falls into the meaning. Then you get into the legal wrangling as to what is the interpretation of that term.
Right, but I mean, the power isn't being given to the prosecutor.
It's a civil case, right? So I misspoke, you're right. So whoever is filing it, but you're right. So then its discretion is being given
To the judge.
and it's a
Yes.
wide discretion, yes.
Yep.
Thank you.
I think Jay Johnson wanted to speak, Mr. Vice Chair. You're muted, Jay.
Thank you. Thank you, Senator Sears. Actually, I'm assuming I may be mistaken. Are we talking about section 6 at this point or?
Yes.
Oh, okay. So I guess my question would be, this provision is intended to mirror federal law. And federal law includes the final order against stalking. And I was wondering if when Eric took a look at this provision in order to mirror federal law, whether he had the chance to look at this sort of the definition of stalking as a federal offense versus the state's definition of stalking. To my mind, to the extent that this is intended to mirror federal law, this mirrors federal law. So I would say that unless there's some substantive difference between stalking in federal law and stalking in state law, I don't know why we would change it. It's no broader or less broad than the context in which it's issued normally. And stalking, is my understanding in Vermont, a stalking order is very difficult to get, that it does not relate to minor conflicts between neighbors. I think that the court holds stalking orders to a very high bar. And I know that that may be preponderance, but generally speaking, it's difficult to get a stalking order, is my understanding.
So I'll respond on 2 points there, because that issue of the parallel with federal law also came up at the last hearing. But first, to respond to Senator Norris's question and what Attorney Johnson was saying, yes, so it is a preponderance standard. So it is a more likely than not standard for the civil stalking order. But there is a distinction in federal law in this case, because the federal stalking prohibition only applies to family members and family members and household partners, as the feds have defined it. So in that sense, to the extent that the stalking order is issued against a family member or a household member, it would be parallel with the federal law. But the Vermont definition in subdivision 3, as we've been talking about, includes a broader range of people. And in fact, the civil stalking order is limited to people other than family members and household members. Those people have to get an RFA, relief from abuse order. So it's because of that distinction, subdivision 3 does allow a broader range of people to be prohibited in the federal statute.
And personally, I prefer that. Because I think we're, in the final analysis, we're trying to err on the side of people not being killed. So, to put it bluntly.
Does a judge currently have the ability to issue an order that the person not possess a firearm currently? In Vermont?
You mean generally, or are you talking about a stalking order, Senator Stevens?
Stalking order, could the judge, as a condition of that civil stalking order, say you shall not possess firearms?
That is a good question. I don't know the answer off the top of my head. I'm checking out the stalking statute right now, see if there's anything specific said about.
If the judge could do it, then, I would go with the federal definition. If a judge could still do it on their own volition.
Well, it does say that the court, so if it does issue the stalking order, court shall order the defendant to stay away from the plaintiff or the plaintiff's children or both, and may make any other order it deems necessary to protect the plaintiff or the plaintiff's children or both.
So what I'm worried about here is this, once again, we diverge anywhere from the federal definition. Even the federal definition may end up, as well as the relief from abuse order, those all may end up being challenged under the Braun rule. But I think if we diverge much from what the federal definition is, we take a chance of almost losing. And I would hate to lose that ability that they currently have. If the judge currently could do it.
I would defer to the practitioners in the room about what judges do. I remember when we changed the law recently on relief from abuse orders, there was some, part of it was that it was clarity that some judges felt they had the authority and other judges felt they did not. I don't know if it's similar with stalking orders.
Yeah, good point. Anyway.
Senator Volsky has a hand up.
Yeah, I certainly appreciate that judges may have this discretion now, and I've certainly heard from constituents that the training around things like stalking and domestic violence may not be adequate for judges to either know they can or know when it's appropriate to take action like this. So, and maybe this isn't the place to address that, but I know that domestic violence and things like stalking is something that I've had multiple constituents reach out to me pretty frustrated, actually feeling that the judges really weren't keeping their safety in mind.
Well, I think we could hang up all day on this one. So I'll leave it to the majority of the committee to leave it in or take it out.
Senator Brewer.
I would support leaving it in.
I would support taking it out.
It's 1-to-1.
Back in that.
I definitely have concerns with the broadness of it, but I think that the protection of people who are being stalked outweighs that for me. I'd love to see us put maybe in another place, like maybe have 2 different kinds of stalking that gets at dangerous stalking versus neighbor disputes. But for me, this is about keeping people alive, and so I would support leaving it in despite my discomfort.
All right.
Similar to that line, I think I'd be fine with leaving it in and also trying to, yeah, I'll just leave it at that. I'm fine with leaving it.
Then I will support leaving it in as well. And so Eric, we can move along. Are there other areas of the bill where there's disagreement or concern with the changes that are made, or things that were changed earlier on that anybody would like to raise at this? Jared.
Thank you, Senators. I just wanted to identify that in section 1, page 3, line 7, I would suggest that maybe there would be more clarity about the purpose of the language if the phrase has been was changed to the word is. I believe that would give more temporal clarity to a judge trying to apply that section. So by way of example, if youthful offender has been revoked or the Supreme Court has denied, the order has been appealed, this would clarify that it's to currently active youthful offender status, not to any order, whether it's still in force or not.
Any other comments on that? Let's just clarifying.
I'd be fine with changing that if according to people who practice, it'll be more clear to folks who practice and judges, and I think that I'd be fine with that.
I'm fine with that.
Yep.
Any place else?
Yours?
Yep. Yes.
So, I'm sorry. I just wanted to point out again that in section 7, which accepts 18 VSA 4253, which is a felony, basically carrying a firearm while committing a drug offense. I just was again wondering whether that could also, to the extent we're not going to delete this reference because 18 VSA 4253 has its own penalties. whether the committee would consider adding that as well, the similar language to that provision of law as well, that the offense shall be considered a violent act. Because what we are seeing is that carrying firearms while committing some of the offenses, drug offenses, are where we're seeing some of our most violent crimes. That's the only, I made that point last time, and I just thought it would be worth mentioning again.
Well,
Senator Sears, Rebecca from the Defender General's office would like to.
okay, go right ahead, Rebecca.
Thank you, Senator Sears. I voiced my concerns informally, but have not testified formally before this committee on the significant concerns about declaring whether it's that section 7 while committing a felony or other sections, that the act itself is violent for purposes of bail. And as the questions from Senator Hashim to Legislative Council have indicated, but I want to make sure it's clear and certainly address it directly. Jay Johnson's request to add additional offenses to what is declared violent for purposes of hold without. It is directly contrary to the plain text of the Vermont Constitution itself. It is not enough that the carrying of a firearm, the rubbing of serial numbers from a firearm, the straw purchasing of a firearm, you can't just declare it violent. The Vermont Constitution requires the element of the felony itself involve an act of violence, but here's what hasn't been talked about: act of violence against another person. That is the entire phrase. It's not just an act of violence. So every time there's a declaratory, this shall be considered an act of violence, that's only part of the picture of what actually Section 40 of Chapter 2 of the Vermont Constitution requires. Now, the Legislative Council said that the legislature has so used the same language in other statutes, and that is true, but those are involving felonies where the elements involve necessarily another person and use of force against another person. So lewd and lascivious conduct against a child, in that statute it's declared that that shall be an act of violence. The Vermont Supreme Court has interpreted that and said, yes, that's consistent with the Vermont Constitution. So here in section S4 and the sections, I think it's 4, 5, and 7 with this latest draft, you're missing that against another person and also the inherent act itself being violent. Merely carrying a firearm in the commission of a felony, that can involve felony unlawful trespass. It can involve driving offenses involving felonies where you have a hunting rifle in your car. That is not against another person. It's not inherently a violent act. So that is in and of itself not meeting the basic terms of our own Constitution and putting into vulnerability, striking the entire statute because you cannot save it where the committee is just going full forward without regard to that important language in that section. At the very least, I would add the section 7. Instead of saying that it's just a mere carrying, look at again what the constitutional language requires: using a firearm and threatening or using a firearm against another person, right? And I'm happy to share with Eric the case law from the Vermont Supreme Court later on, where they've interpreted our felony offenses involving firearms consistent with Section 40.
Thank you.
Jared has his hand up.
Thank you, Senators. I just wanted to note that I appreciate the Defender General's and Attorney Turner's interpretation, but I would offer that I don't think we share that interpretation. First of all, in the sections that the committee is considering here, the intent to use in a violent manner is inherent in the elements here. For instance, defacing a serial number. I believe I did mention in my testimony that the only reason that you would do that is to evade detection. Same with straw purchasing. And one typically intends to evade detection to do acts of violence where forensics would be involved. And that would be akin to essentially an attempt, so you don't have to complete the act in order for the hold without bail statutes to apply. The attempt is sufficient to bring that provision into place. Certainly, there could be motion practice about this, and I think that the attorneys would be able to vet those arguments through the court, but it's not so clear that the committee should be concerned that it's doing something that appears flagrantly and unconstitutional, because I think there are arguments on both sides.
I think, I'm seeing and hearing both sides of this conversation regarding these sections, and I feel like it's loose to say that there's a tenuous connection between saying that defacing the firearm serial number is an act of violence against another person or contains a threat of an act of violence against another person. So, do we have a definition of what violence is that we can use here?
A definition of violence?
Yeah, I know what?
You have a definition. You could say, I know you define serious bodily injury, for example, that's defined in statute. But the use of the term violence, I think, is intended to track the word that the Constitution uses.
Yeah.
So, and as I often do, threading the needle between the different positions that you've heard on the constitutionality, but I think it's a fair point about the constitutional text saying violence against another person. But as you say, it may not be that therefore the statute is facially unconstitutional. It may be that in application to a particular charge where there wasn't any violence involved, maybe in an as-applied challenge. I don't think it does raise a possibility there could be a successful constitutional challenge there. But whether or not a particular, for example, defacing a serial number or straw purchasing, there's appear to be arguments on both sides as to whether or not that is an offense of violence. Generally, it might not be in a particular case. And
the reason I asked for, if we have a state definition of violence, I was looking up the U.S. definition of violence in 18 section 16, and part of it says that it involves a substantial risk that physical force will be used against a person or property. That was part of it, and so that's why I was trying to figure out if maybe we have a definition that would be. And
Jay, did you have a comment on this?
I do.
No, I had Jay Johnson. I'm sorry, Rebecca.
Oh, I'm sorry, I can't tell.
Oh, thank you, Senator Sears. Yeah, the only thing I would also point out is 18 VSA 4253 actually does refer to use of a firearm. The title of the bill is the law is use of a firearm while selling or dispensing a drug, and then goes on to say a person who uses a firearm during and in relation to selling or dispensing a regulated drug in violation of a number of sections shall be imprisoned or fined. It also says it relates to trafficking, and it also defines use of a firearm to include the exchange of firearms for drugs. And this section shall apply to a person who trades a firearm for a drug and the person who trades a drug for a firearm. So anyway, I would say that also actually goes to use, which suggests violence against a person, may or may not, but I would agree. I would tend to agree with Eric that it will depend on the situation, and the judge has discretion here.
Now, Rebecca, did you have a comment?
The Vermont Supreme Court has defined the meaning of violence as it's used in Section 40 of 7553A in a lot of its case law where it's been challenged, right? Whether or not it falls within that statute. State v. Bryan, 2016, Vermont 16, looked to various dictionary definitions of violence and said violence may be defined as an exercise of physical force so as to violate, injure, damage, or forcibly interfere with personal freedom. Another dictionary definition, violent actions are those characterized by unjust or improper force. Suggests that to determine whether a given exercise of physical force is violent, it should be considered with reference to its effect on the recipient. So it also confirms that it's circumstance specific, as suggested that Title 18 felony offenses would meet that definition. And the current law already covers that it would already qualify as a 7553 offense. You don't need to add an additional section here establishing it.
Well, I think these arguments could generally be made in the House as well. And I'm comfortable that what is before us here, the only thing I could say is to cover the idea of somebody having a rifle in their car, intentionally carrying a firearm while committing a felony, I suppose could help. But I don't see this, I've listened to both sides, and personally, I'm comfortable with the way it's drafted here in all three cases.
I just had a quick question about the legal definition of carrying. Would a hunting rifle on my truck's rifle mount be considered carrying or in possession of? Or like, there's so many different words we use around this, and I just want to understand.
I think it could be.
Okay, so carrying doesn't mean on my person.
Carrying might, in possession of it, might not. In possession of is broader.
And is the language in the bill in possession of or carrying?
I'm trying to find it.
Okay, so
Carrying.
Carries.
Right.
Because if carrying is on my physical person, I feel comfortable that it would exclude a driving offense where I happen to have a hunting rifle
I don't
on the
know,
truck rack.
I don't, just want to make it clear, I have not researched that issue, I don't know off the top of my head whether it's limited to those circumstances, and there may be cases that apply it for property.
Okay. It's about as clear as mud.
Right.
But the person's still committing a felony. Is there anything else in the bill? So as I understand it, we've got a slight change in one section, Eric, and you're going to check on this issue of carrying a firearm and whether it needs to be more specifically defined.
I think there's two, just so we know, there are two slight changes, though. There's the one change to add Vermont.
Yep.
And then change has been to is on page 3. I think those are the only two changes that I've heard so far.
Okay. You want to take a break until 11:15 and come back and see if we can make some final decisions?
I think that sounds good.
That okay with the committee and those witnesses?
Sounds good.
Just an FYI that I'm going to be next door and gonna help them up there at 11:30 on 36. Your hospital firearms field center here.
Okay. All right. Well, it gives us 15 minutes to see if we can come to conclusion and get a final version.